Community land trusts grew out of the civil rights movement in the U.S. The first community land trust was established 50 years ago, led by Slater King, cousin of Dr. Martin Luther King Jr. Douglas Community Land Trust builds on this legacy, the spirit of Frederick Douglass, and the work of more than 250 community land trusts in different regions throughout the country. Racial and economic justice center our mission. Douglas Community Land Trust is a membership organization. We invite you to join.
Thank you everybody for joining early even today. Really appreciate you all taking the time. We're gonna kick things off probably 2 or 3 after 6 to give people a couple minutes to come in and join the right interpretation channel. Laura, whenever you want to kind of let people know about the interpretation in Spanish and English.
Sure. Do you have the slides?
I do. Let me pull it up real quick. Well, I'm sorry. I'm struggling to pull it up. I thought I had it on my fingertips, but that is not the case.
Do you want me to share my?
That would be great if you could.
Give me 1 second. Can you see my screen now?
Not quite. Well, Carol, would you mind stopping sharing for a moment?
Okay.
And then you can put it back up.
Can you see my screen now?
Yep.
Yes.
Good evening, everyone. Buenas noches a todos. We are going to offer Spanish interpretation today, and I'm going to give you the instructions. You need to click in the interpretation globe that is located at the bottom of the Zoom screen in the toolbar. Then you will find the different languages. You may need to select either English or Spanish. You also have the option to mute original audio. And if you are using a cell phone, you will need to click on the 3 dots. It says more. Then you select your language, English or Spanish, and then you select done. And also you have the opportunity to mute your original audio. Hola a todos, las instrucciones para unirse al canal de interpretación son
Hello,
las
everyone. The options to join the interpretation options are the following. Select the globe icon in the lower part of your screen on the toolbar. You will click on the globe and you'll find English and Spanish. Please select your preferred language. You also have the option to mute the original audio. If you're using a mobile device, a smartphone, a cell phone, click on the three dots that say More, and then choose Interpretation. Select English, Spanish, Accept, or OK, actually in English, and then you have the option to mute the original audio as well. Thank you so much, and we will begin right now. Thank you.
Thank you, Adam.
Excellent. Well, thank you everybody for joining today. We are gonna kick things off. My name is Adam Malone. I'm the Director of Stewardship at the Douglas Community Land Trust. And to give us a quick intro to today and say a little bit about our organization is our board member, Kiva Dennis. Kiva?
Thank you, Adam. Good evening, everyone, and welcome to Douglas Community Land Trust training session tonight with the topic, can your condo or your co-op board pass the accountability test? So we're going to find out this evening. As Adam mentioned, I'm on the board of the Douglas Community Land Trust, and if you're not familiar with this nonprofit organization, we are a racial and economic equity organization. Our mission is to preserve affordable housing in perpetuity. So not for a short period of time, but for the long term, for current and future generations. And we also offer stewardship services to condos and cooperatives. So similar to the kind of training that you're receiving this evening. So I'm a lender in my day job, and I make loans to cooperatives, development loans. And so this topic is very, very important because I want to see that there's good governance at these cooperatives, right? That they're vested and they understand what the responsibilities are. So that will give me assurance that the loan through my lending organization will eventually be repaid. So this is a really, really important topic. Next, I want to thank a few people. First of all, our presenter this evening is Kara Spencer. And Kara is an Assistant Attorney General in the Public Integrity Section of the Office of the Attorney General. Thank you very much, Kara. We're delighted to have you. And of course, we want to thank our community partners that, so many organizations come together to make an event like this possible. There's MICASA, Housing Counseling Services, LEDC, Latino Economic Development Center, and Neighborhood Legal Services. And you heard a little bit from Laura earlier. We also want to thank our interpreters from Global YNS, Laura and Ryan. So without further ado, I'll turn it over to Adam, our Director of Stewardship at Douglas Community Land Trust. Thank you.
Great. Thank you, Kiva. It's a pleasure to have you on the board. Just as a note, we are a membership organization and our board is democratically elected. Keep that in mind. We will hear a little bit from our community partners and the work that they are doing towards the end of our programming. But right now, I'm going to hand it off to Kara. And in the meantime, please, you can put any issues that you're having with technology into the Q&A, and I'll do my best to answer them. Along with, if you put any questions you have as they come up into the Q&A, we will address them within the flow of the presentation as we can, or have it at the end And we can also have the opportunity perhaps to open things up and for a little bit of brief discussion for more complicated questions. So Kara, thank you again. Glad to have you on, and please take it away.
All right, thanks, Adam. Thanks, Kiva and Laura and Ryan and Douglas Community Land Trust for hosting this event and for making it possible. And thanks to all of you in the audience for coming. We really appreciate the opportunity to get to talk to people about governance, about board accountability in housing cooperatives and condo associations in the district. Housing is an extremely important issue for our office, and for it's an extremely important issue for our office. As Adam said, my name is Kara Spencer. I'm a trial attorney in the public integrity section of the Office of the Attorney General for the District of Columbia. And one of the traditional roles of any state attorney general's office is oversight of nonprofit corporations. It's the role of the Attorney General's office to ensure that nonprofits are appropriately governed and that their assets and funds are used to support the nonprofit's purpose. Here in the district, as I'm sure many of you know, many condominium associations and housing co-ops are organized as nonprofit entities. So our oversight responsibilities apply equally to housing cooperatives and to condominium associations. So it's a part of our role to make sure that governance is effective and that the funds of the co-op or the condo association are being used to further the purpose of the association, which is the maintenance and operation of the co-op or condo. My goal today is to explain from the members' perspective, the co-op or condo association's members' role in shared governance and in holding your board accountable. And I'm happy to take questions, put them in the chat, and I'll take them up. And I am looking forward to having some good discussion. Okay, let me hold on a second here. Pardon me. Okay, here we go. So a couple of basic principles. What differentiates a co-op or a condo from an apartment or from, or a single family, other kind of housing is, there are two things really. There's self-governance, where a group of people jointly owns a housing complex and collectively makes decisions about how to maintain it. We'll be talking about self-governance today. The other aspect is shared ownership. Co-op or condo members, well, the structure is set up differently in co-ops and condos. Housing co-op members don't own their units, but instead own a share of the whole and have a right to reside in a specific unit and a right to use the common areas and participate in decision-making for the co-op. In a condo, members own their own units and collectively own the common elements of the condo association. So the first question, I want to set out what will, the plan for this evening's presentation. We're going to talk about the law that governs co-ops and condo associations. That's a combination of district statutes and the association's own governing documents, its articles of incorporation or association, and its bylaws. We'll also talk about how to elect and maintain a legally compliant board. Both the statute, the DC statute, it's called the Nonprofit Corporations Act, sets requirement. It tells you how to, what the rules are for electing a board, the number of board members, how long they can serve, the process. There's certain aspect, the process for elections. So we'll talk a little bit about that. Also, your co-ops or condo associations bylaws will give more details about how the board has to be constructed. We'll also talk about annual and special meetings, board decision making, when a board's decision is properly authorized. And I'll say a little about what options members have when they disagree with a decision that the board makes. And finally, because transparency it's an important component of accountability. One thing I want to focus on is how can members get the information that they're entitled to from the board or elsewhere if need be? How do you get the information that you're entitled to about your co-op or condo? So, okay, so what's the governing law? DC statutes that govern are the Nonprofit Corporations Act. There is also the General Cooperative Associations Act and the Limited Cooperative Associations Act. So note also that a condo association may be a nonprofit corporation, but it's also subject to the District of Columbia Condominium Act. I will not be focusing on the Condominium Act today. I'll be talking about Title 29 of the DC Code, the Business Corporations Code. Each co-op or condo also has its own governing documents, which are the Articles of Incorporation or Association and the bylaws. The idea here is that a co-op or a condo association is created under some state law. Every corporate, like any other corporation, it's created under the law of some state, and it's governed by the law of that state. So if your condo association is created as a DC nonprofit corporation, it is subject to the DC Nonprofit Corporations Act. And it's legally required to comply with the provisions of that act. The Business Corporations Code generally gives corporate entities a lot of leeway to set themselves up and organize themselves the way they want to, the way that works for what they're trying to do, for what that corporation is doing. And the way that a corporation sets more specific requirements on itself, on governance, for instance, on processes, is in the bylaws and the Articles of Incorporation. The Articles of Incorporation and the bylaws are like the law. They have the status of law for your cooperative or condo association. So it is, we see it in our office as a violation. If a condo association violates its own bylaws, that is a violation of DC law also, because all corporations are required to, by law, to comply with their own bylaws. Okay. All right, so I actually said a lot of this. I want to say about membership corporations. So the DC Code, allows for there to be member corporations where members have specific rights to select the board, rights to obtain information about the corporation, rights to vote on certain decisions that are before the condo association or co-op or any corporation. So because co-ops and condo associations are membership corporations, the members have, or the owners, have certain special rights that are set out in DC law, and they are further explained in the bylaws or the articles of incorporation. Okay.
No, sorry, Kara.
Sure.
Do you mind if I interject right here? We got a couple questions.
Oh, sure.
What is the best way for people to be able to determine which of the different, I guess, flavors of co-op and statutes they should be following? How would they know if they're a general cooperative association or a nonprofit corporation or was it LCA? Where would they look to be able to tell?
Okay, that is an excellent question. And there are several places you can look. One place you can look is online. DCRA has an online record search called Access DC. I use it all the time in my work to find out what kind of corporation something is. If we have time, I can walk through how to use it. It's pretty straightforward, but it will tell you. It will tell you whether your condo association is a nonprofit or a general cooperative association, a limited cooperative association. It gives you a lot more information about that was provided to DCRA when the co-op was founded. Who is the registered agent? The registered agent is the person or entity that you have to contact to sue the co-op. There's also a record of the required 2-year reports, whether those have been filed. It will indicate whether the corporation has been revoked, which is something that's important to know as a member of the association, whether it's in good standing or whether it's been revoked. So all of those things you can just find out yourself by going to Access DC. It's a DCRA search tool. That's the first thing you can do. The second thing you can do is just contact your board. Your board is required to give you copies of the articles of incorporation, any amendments, the 2-year reports that it files with DCRA, and the bylaws, and any amendments. So those documents, really, it's the articles of incorporation that will tell you what kind of entity you are. It's going to be in the articles of incorporation. So those are 2 ways to find out. Your board should tell you, but if they don't, you can just get it online, and I'm happy to walk anyone through that. Was there another question, or should I just kind of keep going?
So that's Access DC. Is that the .dc.gov? I'll look it up in
Okay.
in the interim. And then what's the other? It's articles of incorporation or articles of, is it association?
Of association, yeah. So a nonprofit corporation, the articles are called articles of incorporation. And if it's a general cooperative association, they're called articles of association, but they really are very similar documents. They say what the purpose is. They say whether it's a member corporation. They're just certain information that these articles will provide. Very basic information about the kind of corporation it is, the kind of corporate entity it is. I mean, I could share my screen and walk people through that if they want to see, but maybe I'll work through and then we can do that at the end if there's still interest.
That sounds perfect.
Okay. All right, so articles of incorporation are the founding documents. These are available at DCRA. They're public documents. You can't get them on that DCRA Access DC website, but you can get them from DCRA. DCRA may not have the bylaws, but you can. One place, if you are a condo association, your bylaws are required to be filed with the Recorder of Deeds. That's another search tool, but you can get them online. They should be filed with the Recorder of Deeds. That's a requirement of the Condo Act. So that's the Articles of Incorporation or Association. The bylaws, they're a lot longer, and they really set out all of the specifics about rules for board elections, the frequency of board meetings, the frequency of member meetings, how directors are elected, how officers are elected, how certain decisions are made, how members can call a special meeting. And they set out a lot of sort of specific information about how the co-op or condo association is going to be run. And they can differ with each co-op. And as long as they comply with DC law, they're fine. So there can be different requirements in different co-ops depending on how the bylaws are set up. So for instance, some condo associations require that the board be composed solely of resident owners. So if you own a condo and you're renting your unit to somebody else, you can be a member, but you can't serve on the board. But some condo associations don't require that. They say that as long as you're a member in good standing, you can serve on the board, even if you don't live in your condo. So those are that's an example of a kind of a difference between, condo associations can set that up how they want. And they can have different rules in the bylaws. Okay, oh, I got ahead of myself. Oh, question 2. Wait, we have a quiz. Adam, can we do that quiz question?
Yes.
All right,
Yeah.
This is a quiz question. So I'll give everyone time to read it and answer. Give your best answer and then we can talk about it.
I will say, if you've ever talked to an attorney, one of these answers might jump out at you. All right, votes are slowing down. I'm going to go ahead and end it in 3, 2, 1. And here are the results. Oh, a little bit of a split.
All right. Okay, this is interesting. Okay, so as Adam anticipated, the right answer is it depends. And what it depends on is what's in your bylaws and your articles of incorporation. So the Nonprofit Corporations Act in the district does allow a nonprofit board to set its own compensation. So it's not illegal for a board to compensate itself for the work that it does. Now, the compensation has to be fair to the corporation. It has to be fair, because that's what we nonprofit lawyers call a conflicted transaction, because the board is the same group that is voting on how much it's going to be paid. So they have a conflict of interest in that decision. And there are special rules that apply to make sure that those decisions are fair to the co-op. But the law permits nonprofit board members to be compensated. However, many of the governing documents of many co-ops and condo associations, just like many nonprofits, prohibit board compensation. That is very common. It is very common for a nonprofit organization, including a condo association or co-op, to prohibit board members from being compensated for any work that they do for the condominium or co-op. But some bylaws will allow it. They'll allow limited compensation. So you just have to look to find out the answer for your co-op. You need to look at the articles of incorporation and look at the bylaws. And that will tell you whether it's permissible for your condo association. Okay, so I've just listed out here a few examples of the kinds of things that will be explained in the bylaws. How do new members join? How are meetings going to be conducted? The member meetings and the board meetings. How many members or directors are needed for a quorum? If you have a 7-person board, but only 3 people regularly show up, then what happens? Can that board validly make decisions for the whole condo association? You have to look to your bylaws to get the answer to that question. The bylaws also will say how many directors have to be on the board, or how many officers have to be on the board. They may set terms for officers and directors. They may set rules for elections and for board decision making. So some bylaws of some condo associations say that there are certain decisions that are so important that the board can't make those decisions by themselves, and the vote has to go to the full membership. Examples that I've seen in some bylaws are the decision to move from having a professional property management company to being self-managed by where the owners effectively manage the condo association themselves. So certain important decisions, sometimes the bylaws give those decisions to the full membership, or may even require a supermajority of the membership to approve. But it depends on your bylaws, what they say, because some condo associations don't have those requirements. The bylaws will also say whether directors can be compensated. However, you should also look at your articles of incorporation and association, because they may well speak to that question as well. Okay. All right. So how to elect and maintain a legally compliant board. So the board of directors for any nonprofit, all of the corporate powers of the nonprofit are vested in the board. The board has the authority to manage all of the corporation's activities. So the board is really running the show. And anyone else who's doing work for the condo, whether it's a management company or vendors who are doing gardening or doing other work for doing repairs, they are all working under the supervision of the board. So the direct, and how many directors? For a nonprofit corporation, there must be at least 3 directors. For a general cooperative association, there must be at least 5. And directors are in a membership corporation are elected at the annual meeting, unless the bylaws provide differently. So that's when those elections take place. But elections may be for more than a 1-year term. In fact, they typically are. But elections take place, directors are elected by members at the annual meeting. Okay, also, do you see where it says here DC code 29-206? That should be 406, and I apologize for that. And I'll add here with these statutes, I have a lot of these sites in here. If you want to read it, it's real, you can just type that whole phrase, DC code, don't worry about that section sign, 29406.01, just type that into your Google search box, and then the statute will appear, and you can just read it and see what it says. That's true for any statute, DC, federal, any state. You can always get those online. All right. Oh, okay. So your bylaws, as I said, you're a nonprofit, you must have at least 3 directors. Cooperative associations must have at least 5. Your bylaws may require more. Your bylaws may require more. How long does a director serve? The bylaws will tell you how long a term is, except that DC law says that there can't be longer than 5-year terms and 3-year terms for cooperative associations. Although DC law does not require it, directors typically serve staggered terms. That's to promote continuity on the board, right? So that you have, some people who have been there for a while and they understand how things work, and they can bring the new members up to speed. But that again will be in your bylaws, whether that's required. It is a good practice to just maintain continuity of operations. Okay, removal of directors. Sometimes we do get complaints in our office sometimes from members of condo associations or co-ops about where they don't like things that their directors have done. And so sometimes people have questions about how to remove a director who's currently serving on the board. So the basic rule in the statute is that if the members have the power to elect a board member, they also have the power to remove that member. The bylaws will provide more detail about the process and about how you would do that. For instance, one process that is in a lot of bylaws is if enough members want a special meeting for any purpose, including removal of a director, they can petition the board for a special meeting and say, we want a special meeting to vote on removing this director. And if you get enough people to seek a special meeting, the board has to hold a special meeting. That's DC law. They must hold a special meeting. And then, so DC law also says if the co-op or condo association holds a member meeting to consider removing a director, the notice of the meeting should say so, right? So everyone in the condo association or co-op is notified this meeting is going to be about removing this director, and there will be a vote. So that's also a requirement of DC law. The bylaws will also provide more detail about the basis for removing a director. Some bylaws say that a director can only be removed in the middle of his or her term for cause, which means basically there has to be a really good reason, like the person broke the law, or they stole something, or they're pocketing the money, or they are not able to do the job. But some bylaws say that removal can be for any reason, without cause. So let's say people just thought, you've been doing a fine job, but we want this person to be the director. So that could be a sufficient basis. If your bylaws say that members can remove a director without cause, that can be a sufficient reason, as long as you have enough members who are voting to remove that board member. That's that process. Oh, question 3. Adam, can we do question 3? All right. Question 3. So
And then,
let's,
Kara, I got a couple of questions I think we can answer together
okay,
after you go through this
great.
example. Kara, I guess real quickly, can you clarify that whether or not directors and officers can be the same folks?
Well, that's the quiz question. I will
oh,
clarify that. Can
oh
they
my
be the
goodness.
same folks? We
Somebody
will
should
clarify that
facilitate this.
shortly.
Oh my goodness.
Or I could talk about it now, but that's the question.
No, you are right. I should read my own quiz questions. We are having a lot of really detailed questions coming in, so
Oh,
I'll use
I
that as an
can't see
excuse.
them. Wait, is it
They
in
are.
Q&A?
I am curating them, and I'm lumping them together by topic. So we will
Okay.
get to them.
I
Okay,
just
ending the poll
clicked
now.
Q&A. I
Yeah,
see them all. Okay.
there's a lot. I've
All
been
right.
putting some text
Good.
answers.
Good.
So here is the results.
Okay. All right. So the answer, hold on a minute. The answer is, are the board members and the officers, e.g. president, secretary, treasurer, vice president, the same people? Not necessarily, right? So the correct answer again is that it depends. So the way the structure works is that the directors, the board of directors runs, controls the cooperative. They are in charge. The directors, the board, selects the officers, right? So again, the bylaws might set it up differently. Your bylaws might allow members to choose officers directly, but the typical structure is members select directors, directors select the officers. The officers might be also members of the board. Often they are, but they don't have to be. So you could have a board of directors say, well, we think this other member of the co-op would be a good treasurer because this person knows a lot about managing finances and we trust this person. Or we think this person would be a good secretary because this person is so reliable and we know they're going to take good minutes of the meetings and be responsible about distributing them. So the officers don't have to be on the board. They can be. So the president and as I'm clarifying here, the president and the vice president must be board members, but the secretary and the treasurer need not be. Okay, so that's from the NCA, the Nonprofit Corporations Act. And the officers are accountable to the full board of directors. And anyone who is hired by anyone that's hired to run the co-op, like a management company or a vendor to repair something, to do a plumbing project, a construction project, they are, they are subject to the control in the first instance by the board, but also by the officers. And the officers have certain roles in running meetings, managing finances, and making sure that the board keeps all of the records that it is required to keep of the decisions it has made and the records of meetings.
So Kara, just to
Yes.
kind of get through these, so can you let me see. Folks are concerned about conflict of interest and either like with an individual or an LLC that they own and operate. Can you very briefly note or remind me that we're going to address this later. The general process for conflict of interest,
Yes.
if it extends beyond just the natural person.
Yes, it does. So I'll talk briefly about that right now. So the key provision, if you are the kind of person who wants to look at the statute, it's in DC Code 29-406.70. That governs conflicting interest transactions.
One more time.
DC Code 29-406.70. That's the, should I put it in the chat?
I was typing it into the Q&A.
Okay,
Thank
awesome.
you.
Okay, so you can type that into your Google search, and you can see the provision. Sorry, so it's not the best, it's not the easiest to understand. It's written in a crazy way, but basically, the way to think about conflicted transactions is that a conflicted transaction is any transaction between the board and any director, or any entity that in which the director has a significant interest. So if I'm on your board and I also own a landscaping company, and the board is considering hiring my landscaping company to do landscaping for the condo, that's a conflicted transaction, even though it's not a contract with me. It's a contract with an entity that I control or that I have a significant interest in.
What if my cousin owns the landscaping LLC?
So that's a more difficult question. I think that the board should really err on the side of transparency with all of these transactions. The board should err on the side of transparency. So to make it clear what, to get a clear bid from that entity, to get bids from other companies that do the same, that would provide the same service, so that you can show the condo association that, look, my cousin really did offer the best deal. And this is the fairest deal for our condo association. It's also best practice for a director, if there's any appearance of conflict, for that director to not participate in that decision, to just step out. Don't be at the meeting where that is discussed. Don't try to influence that vote. That is the best practice if there is a conflicted transaction, and it's the best for the members, and it's the best thing for the director too. That protects the director also.
And noting that in the minutes would be very critical, right?
Yes, the minutes should be crystal clear on this subject. What the decision was, who voted, who recused themselves, the outcome of the vote, all of that. It may not be required by law, but it is the best thing to do when you have any kind of conflicted transaction.
Super. One last wrinkle on this. If the officers are and board of directors are described as being indemnified, can they still be liable for actions that they take?
Yes. There is, again, it depends on your bylaws, but the NCA requires nonprofit corporations to indemnify their directors and officers from certain kinds of suits. But that doesn't mean they can do anything. So if a director is, for instance, pocketing the condo fees and using them to buy a new car, they are liable. right? They're not, they're not, it's a long answer because they could be, if they were sued, they could be entitled to a defense from an insurer hired by the condo association. I've seen that happen in my cases, but it's a complicated question, and I'm not prepared to really give a complete answer right now.
That
But
was very
indemnification,
helpful.
yeah, okay. It doesn't mean they can do anything. It just means that they are if they are sued, the condo association will provide them with a defense, and there's certain kinds of, I don't know, losses that they're protected from being personally liable for. All right, I am. I feel like I'm.
Thank you for that.
Sure.
That segue.
Yeah.
I think we can
Okay.
return to our programming if unless you have other things you want to communicate.
Okay. No, I'm gonna bust ahead. Okay, board elections. All right, this is a common theme. Consult your bylaws. I've talked about this. Members elect the board. Directors elect the officers. It doesn't have to be an election. They can just choose them in some way or other. Members must have sufficient notice of an upcoming election of directors. And they should be able to participate in the election. Members should also know how to nominate someone to serve on the board, right? That should be made clear. That's all a part of keeping your board accountable. Members should also understand the process of how votes are collected and counted, again, so that you can trust the result of the election. If members are not entitled to vote because they owe condo fees or co-op charges, they are entitled to know that is the case. Many bylaws say that a person who is delinquent in fees can't vote or can't serve on the board. That's perfectly legal to have that restriction, but members are entitled to know if they're not entitled to vote for that reason. Okay, meetings. The law requires at least one annual member meeting at a time. Usually it's specified in the bylaws when that meeting, approximately when it's going to take place, and the kind of notice that must be given. Members or directors can request a special meeting under certain conditions, right? So if at least 10%, or perhaps more, if the bylaws say more, up to 25% of members entitled to vote on an issue want a special meeting, they can demand the board hold a meeting on that issue. If the board refuses to hold a meeting on that issue, DC Code gives members the right to petition the Superior Court to require the board to hold a special meeting. And you can see that provision right there. All right, so what happens when you disagree with the board's decision? What can you do? Obviously, the board is making a lot of important decisions, and I don't want to be down on the board. The board puts in a ton of work, and they often get a lot of complaints from people who are not happy with the decision. It's hard to do. It's a real, especially when it's often a volunteer position. But so the board is deciding about hiring a management company, managing that management company, making financing decisions, whether to make a special assessment to pay for some special expense, major repairs, replacement of roof, replacement of boilers, as well as handling emergencies. So all of that's on the board, but and sometimes board members will make decisions that some members disagree with. Okay, so one aspect of board decision making Just a couple things about board decision making is that the board is accountable. They're making decisions on behalf of the members. Boards have a fiduciary duty to the members. They're accountable to the members. Effective boards make decisions collectively through a vote. Sometimes I've seen this where it is effectively one person running the condo association, and there are other board members, but they're not as involved, and there's one person making the decisions. That is not a good recipe because it makes it less likely that the board's decisions will be set out in a meeting and explained and voted on. So the decisions should be made collectively through a vote. Boards must for any decision, make a written record on the proposal that was voted on and the outcome of the vote. So let's say it's, do we want to hire this management company? These 3 board members voted yes, these 2 voted no. The board minutes should reflect the outcome of the vote and each board member's vote. And again, your bylaws may give all members the right to participate directly in certain decisions. It's just look at the bylaws and you'll see what they say. If enough members disagree with the decision, they can demand a special meeting. I've gone through this a little bit. The members' demand has to comply with the NCA and the bylaws. So if I'm the only one who wants a special meeting, that's not enough. The board doesn't have to hold it just because I want it. If enough people petition who are entitled to petition for that meeting, the board must hold the meeting. And if the board doesn't hold the meeting, the members can petition the Superior Court to require that the meeting occur. And a special meeting is also a way that members can raise their concerns with the board. So that's one option when members disagree with a board's decision. There's also, and sometimes this is better, informal methods. Talk to your neighbors. Hold a community meeting. You don't need the board's approval to hold a community meeting to discuss what's going on. Research other options. If you don't like the management company, see what else is out there and what, if there's something better. And then bring the information you have to the board. Try to keep the discussion with the board open. So those are always possible. Question 1. Can we do question 1?
Sorry, I am.
Oh, that's okay. I'm
Okay,
looking at
now.
all the questions.
Great. There's a lot of good questions. All right. Wait. Nope. Oh my goodness. Okay. Well, I think I spoiled it. Wait. Oh no, relaunch poll. There we go.
Okay.
Learn something new every day.
I think we talked about this earlier on, but we can talk about it now too.
This is the correct question.
Yes, this is the right question. Yeah, this is, I know, yes, right. This is the right one.
All right.
How can a member find out whether their cooperative or condo association's corporate registration is current?
Here are the results.
Yes, all of the above, correct. All right, good work. Ask the board, they should tell you. That's information that as a member you're entitled to. Check DCRA, that Access DC website. That will tell you. If it's revoked, it'll say revoked. And then you go to the board because that's a big problem. That effectively means your condo association can't do business in the district until they get themselves back in good standing. Or you could raise the issue at a special meeting. The board is entitled to, you're entitled to that information from the board. Okay, so what other information are you entitled to as a member? First of all, copies of the minutes of board meetings. The board must maintain a permanent record of all minutes of board meetings and member meetings, or meetings of a designated body, which means a subgroup of the board. Sometimes the board might have a finance committee or some other committee, a subcommittee of the board. The minutes of those must be retained. Boards also can take action without a meeting. For instance, they can, if it's some emergency, they can make a decision by email, where all the board members record their votes by email. But those minutes must also be retained, and they must state the decisions the board made during the meeting. They should also state who was there, the date and time, when it started, when it ended, the agenda, what was discussed, obviously decision reached, and how each board member voted on any decision. And one excellent way to make sure that you're holding your board accountable is to pay attention to what it is doing and stay informed about what it's doing. So insist on getting these minutes. Your board can and should make it easy for members to get them, and make them available. And it's your job as a member to review it so you know what's going on. Okay, these are just more about the minutes. The board should, best practice, approve the minutes of the previous meeting at each meeting, so that there is clarity that the board agrees that those minutes accurately reflect the decisions that were made at the previous meeting. The approved minutes should be stored in a place that's convenient and accessible to all board members. And members have a right to see copies of the minutes. What other information are members entitled to? In the DC code, look in the DC code. Your governing documents, articles of incorporation or association, bylaws, any amendments to either that are currently in effect, any general communications to all members in the past 3 years. So you're not entitled to that letter that your condo association sent to your neighbor, just to your neighbor, but anything that went out to everyone, they have to keep, and you can ask for it, and you're entitled to it. The names of all the directors and officers, accounting records, and the most recent 2-year report to DCRA, which, to be honest, does not have a lot of information, but they're required to keep it under the law. Members also have a right to inspect financial information, including and accounting records, if they have a specific reason to do so. Okay, so annual financial statement, including a balance sheet as of the end of the fiscal year and a statement of operations for the year. If there is an independent annual audit, it should be shared with members at the annual association meeting. A condo association, a nonprofit is not required to have an independent annual audit. It's not free. But if they do, it should be shared with members at the annual association meeting.
And if you
yes.
don't mind, I can interject. We had a presentation on how to contract for audits. So if you go to our YouTube page, you should be able to see a recording of that in English and Spanish.
Great, thank you. It is a complicated issue, so it's worthwhile to look at a training. I would recommend that. There's a complexity about condo associations, which are also governed by the Condominium Act. So if your condominium association is a nonprofit corporation, it's governed by both the Nonprofit Corporations Act and the Condominium Act. There are some differences between nitty gritty of the requirements of those statutes. So sometimes it's not an easy question to answer whether you're entitled to certain information about your condo association. So I've set out those basic requirements of, the records that you're entitled to under the Condo Act, but it's also an issue, I'd say, where you may need to talk to a lawyer because the statutes could conflict in some non-obvious way that could affect your entitlement to certain kinds of information. It does get complicated there. Oh, I think we're done. Look at that. So I just want to list these resources. DC Bar Pro Bono Help for Nonprofits. I've got the link there. I think it's worth reaching out to them. There is also this law help link that I have, and you can contact our office as well. Our office does not provide legal representation to members of co-ops or condo associations. We don't represent individuals, we represent the district. However, if you have a complaint, if you know that your condo association is violating the law, you can and should contact our office. We do have authority to investigate potential violations of the Nonprofit Corporations Act and of the General Cooperative Associations Act and of the Limited Cooperative Associations Act. So if there is a violation of the law, don't hesitate to reach out to our office and let us know what's going on. And whether we investigate and what we do is the decision of our office. That's because our office doesn't represent individuals, it represents the district. But we do have authority to investigate, and sometimes we are able to achieve an improved situation through, as a result of an investigation. And that is all I have. I really appreciate everyone listening, and I'm happy to take questions. I see a bunch of them in the chat. So what should I do?
Yeah, we got a couple on foreign or co-ops and condos that are incorporated outside of DC in another state but operate inside of DC.
Okay, so what the question is, like, how does it work if it's a foreign corporation?
Is it so there's, sorry, that was very broad. So there was a couple of different questions. One is like, do they, are they bound by the same laws? How do you know which laws you need to account for as a foreign corporation?
Okay, so that's gets a little dicey. If you are a if you are like a Delaware corporation operating a condo association in the District of Columbia, which happens, more than, it's surprising how often it happens. You are subject to the Delaware. You're subject to the Delaware equivalent of the Nonprofit Corporations Act, rather than the specific requirements of the DC Nonprofit Corporations Act. However, I don't want to get too into the details because it really does depend on the specifics. But if a nonprofit is operating in the district, even if it's not incorporated in the district, it's still subject to the jurisdiction of our office. Like we can still, you can still sue the corporation in DC Superior Court. If that answers the question. I'm not sure that it does.
I think it's complicated is a good place to start, and there are resources available. Kara, what do you think about us giving you a moment to go through the Q&A and pick out some good ones, and then we can hear from our community partners? Do you think that would be a good use of time?
Yeah, absolutely. Yeah, and I definitely want to reserve time for to hear from others because I've been talking a whole lot. DCRA website. I'm starting with. I think I'm going in chron order. DCRA website contain all the cooperatives, condo association, and homeowners information. It doesn't contain all the information. It can't, for instance, get the articles of incorporation from the DCRA website. It will tell you whether your homeowners association is in good standing. It will tell you what kind of association it is. It will tell you who the registered agent is. It will tell you who the beneficial owners are. So it gives you some information. You can just click around and see what it gives you. Some condo associations are not incorporated. The Condo Act doesn't require that a condo association be incorporated at all. So if it's not incorporated, then you won't find it on the DCRA website.
Kara, would all cooperative housing cooperatives, would those all be incorporated?
Well, they're supposed to be. They're supposed to be, yeah, a general cooperative association or a limited cooperative association. Yeah, it's supposed to be, created under a statute. I mean, a co-op could also be an LLC. You could organize as an LLC, and that would also be, you could see that on the website as well. Gotcha. Or a for-profit. It could, however the individuals who create it want to set it up, they can set it up that way.
Kara, I got a couple questions on bylaws and how they relate to statutes and regulations. Okay. And if one is more, if the bylaws are more restrictive, or if subsequent laws have been passed since incorporation. I think we have some elder co-ops here, I guess.
Gotcha.
Can be elders too, since they're people.
Okay. So the way it works is whatever kind of, let's say your condo association is organized as a District of Columbia nonprofit corporation. It must comply with the Nonprofit Corporations Act. The articles of incorporation and the bylaws must comply with the Nonprofit Corporations Act. So if your bylaws let you do something that the NCA says you can't do, then those bylaws are not valid. That provision is not valid. So the bylaws and the bylaws kind of provide the more specific rules that are, within the boundaries, the general boundaries set forth in the Business Corporations Code, the NCA. What happens okay, so there's a question, when was the Nonprofit Corporations Act, Limited Equity, Limited Cooperative Associations Act passed? Nonprofit Corporations Act was part of a revamping of most of the Business Corporations Code in 2010. The General Cooperative Associations Act is kind of a holdover from that earlier time. It's still good law. It still governs general cooperative associations, but it's a little different from the NCA. I don't remember when the Limited Cooperative Associations Act was passed. Another question, does OAG assist in revising outdated condo association bylaws? Do I know of organizations who provide this as a free service? We don't, so our office does not, I can't say that we offer assistance in revising outdated condo association bylaws. I think that what we do is, if we obtain information showing that a condo association or a co-op or any nonprofit, like maybe it's not even housing related. If we get information that they're violating the Nonprofit Corporations Act, we can investigate. And if we think it's warranted, we can issue subpoenas and we could file a lawsuit. So what we do is kind of within those parameters. We don't offer assistance with like, how can we fix these bylaws? The way to amend the bylaws is usually set out in the bylaws or in the articles of incorporation. So the process would be to, call a special meeting, raise it at an annual meeting. Here's an amendment that I think we should use or that we should make. And then you have to get enough members to approve it, right? It has to be voted on. So that's the process. And I might recommend, if you feel like your bylaws are out of date or you think they need a refresh, call around to some other condo associations and see if they've revised theirs recently, and you could take a look at them and see whether you think that they would work for you, for your condo association. That's just an idea, to just find something that might be useful. But that's something where you would need, again, legal advice about what the ramifications of the proposed amendments would be. That's actually quite important to get legal advice for that.
Kara, we have, so do you mind if we take a short break from answering Q&As? Because we have some of our technical assistance colleagues on here who unfortunately the attorneys are not present, but I can speak to that a little bit. But just hear from them on the services. So hopefully this may answer some of the questions.
Sure, of course, yeah.
So we are gonna start off with.
Can I stop share?
Yes, please.
Okay.
Yes, thank you.
There we go.
So we're going to hear from our colleagues at Mikasa. And Ellen, I believe that's you.
Yes, hi everyone. Good evening. Can you hear me all right?
Yes.
Great presentation. Mikasa is a 30-year-old nonprofit. We do a lot of affordable housing and preservation work with tenant associations and cooperatives to help preserve affordable rental and cooperative housing, as well as single-family home ownership. And having worked with co-ops and with Mikasa for well over the last 15 years, I have to say that I learned a lot on this presentation, even though a lot of this is familiar. Really good presentation, and I hope that people are taking away and taking stuff from this that they can use in their association and following up with it. I wanted to point to some resources that Mikasa also provides. If you go to our website, and I'm not sure, I can't see it on the screen, but there is, I believe there's a link in the presentation to our website, but it's just mikasa-inc.org. And if you go to the resources tab of our website, you will see co-op and tenant purchase toolkit and resources for both tenant associations considering becoming a co-op. So I don't know if there are any on this call, but if you know of any, it provides some resources in considering that decision. And it also provides resources for co-op conversion and for limited equity co-ops, including board and member roles and responsibilities, some of the things that were covered on tonight's webinar. And we also provide free training to cooperatives under the Cooperative Leadership Academy pretty much every other month, and in partnership with Douglas Community Land Trust. So I'm sure we'll be able to inform you about those trainings, financial and asset management, oversight, and again, member roles and responsibilities. And if you are in need of a building renovation or a refinance, those are the kinds of technical assistance that Mikasa provides as a consultant to cooperatives. So thanks for having me here. Really great presentation again, and I hope everyone is able to take from it and take it back to their associations. Thanks.
Terrific. Thank you, Ellen. Now our friends at LADC.
Good evening, everyone. Thank you for having us here. And Yes, I am Gustavo Vargas. I'm a tenant organizer with the Latino Economic Development Center. It's a nonprofit organization in the DMV and Puerto Rico. We offer free services to the community in housing, small businesses, and lending. The housing team, which is what the tenant organizing team that belongs to, we have tenant organizing. We support tenants who want to exercise their rights when their buildings for sale and improve conditions, support for new and existing co-ops. Tenant services help with rental assistance and benefit applications, and housing counseling. They support with they offer support for first-time home buyers. And to reach us, you can contact us, the tenant organizing and limited co-op support at 202-540-7439. The DC office for the other departments as well is 202-588-5102. And the tenant support services is 202-681-7381. We appreciate the opportunity and looking forward for next training.
This is the interpreter speaking. It will be possible for you to type the phone numbers on the chat, please?
Gustavo, I can probably do that as well. Let me see. Okay, so great. So while we do that, do we have our friends from HCS, Housing Counseling, on the line?
Yes. Yes, hi, this is Ronald Clarkson. I apologize for not having my camera on. Let's see, but yes, with Housing Counseling Services, I'm one of the program directors there. And much like our colleagues with LEDC and Mikasa, we do housing counseling, we do tenant organizing. We also work with condos and co-ops, and primarily working with folks and trying to do the things that try to keep them in their home. That's our main focus. And so along with all of the counseling on an individual basis, we work with tenant groups and trying to keep them in their buildings if that's their desire. And we also work with folks if they feel like they've been dealing with issues that the landlord may not be making repairs in a timely fashion. We work to try to expedite that. We also work on fair housing matters, housing discrimination. And so there's a litany of things that we provide and services that we provide. We can be reached at our phone number at 202-667-7706. And feel free to ask for any one of our services and you'll be directed appropriately.
All right, thank you, my friend. And unfortunately, our comrades at the Neighborhood Legal Services Program were unable to be here tonight. They are a LSC corporation, funded corporation, and provide free legal services for co-ops and condos. So very, very relevant. I'm very sad that they had a conflict tonight. But they do, in fact, provide legal services to condos and co-op. Or sorry, I believe they're focusing on co-ops. They may open it up to condos in the future. But I will drop their contact information in the chat right now. So we have about another 5-ish minutes before we wrap up. Kara, did you see any questions that you wanted to address in particular?
Well, it was really good to hear from other people. I've been probably talking too much. So I won't be able to answer all of the remaining questions and really give them the time that they deserve. I mean, I could say annual meetings, do they have to take place in person? No, they do not. It depends on the bylaws, whatever the bylaws say. it's complicated though, because I think that during COVID, there were these general amendments to lots of statutes that allowed things to be virtual that were previously in person. And I don't remember, that's sort of a ambiguous answer, but it may be that the statute also allows it. I don't know that answer right now. Is it legal to, if the board tells you that if they went ahead and held the special meeting that was requested, they would be sued? I mean, so I can't give legal advice. You know, that's one thing we can't do. And I'm sure that there is a situation like that. Like there's a lot of complexities and other facts that I don't know. But what I can do is like point you to the statute, right? And what you look at is the statute, the NCA, if you're a nonprofit corporation, NCA, and your bylaws. That will tell you the answer to that question. And you plug in kind of your own facts. Please cite to where in the law it says that officers need not be on the board. I can, yeah, I could find that, but then I would, I wouldn't be answering. I'm sorry. I'm just trying to work through these.
Isn't it that it's open in some instances and closed in others? So it's very difficult. And you know, forgive my basic understanding of the law, but it doesn't always explicitly say this is 100% permitted. But it will close off possibility. So finding something that speaks to that exactly might be impossible. Yeah,
no, that's a good point. That's a good point. And as I'm thinking about the NCA, it says that the president and the vice president do have to be directors. The secretary and the treasurer need not be. But where something is permitted, yeah, Adam is exactly right. The statute doesn't necessarily say that it's permitted. It just is silent. And then if it doesn't tell you it's not permitted, you can do it, right? Unless your bylaws say differently.
And that is something I've seen in most bylaws. They specify that immediately. So to that question, your answer is going to get that answer very quickly in the bylaws in most circumstances.
The bylaws are really, that's why it's hard to give this presentation, because so many of the questions depend on what's in the bylaws, and that differs. You know, different associations have different bylaws. Conflicts. Staggered terms, but you haven't been following that. We elect their board once every 3 years. Is that okay? I mean, if your bylaws say that you have to do something, then you should do it. If the association is getting along fine, just electing a whole new board every 3 years and not having staggered terms, that's great. You could change the bylaws. I think if things are functioning, like a little technical violation is not a super big deal, but strictly, yeah, if your bylaws require it, you should do that. You're required to do it. Okay. Conflicts by the managing agent. So the managing agent is not, or should not be, the property manager should not be a decision maker. The property management company is acting under the direction of the board and the officers. So a decision, if the board is trying to make a decision about, where what they decide might benefit the management company, that's not a conflicted transaction under the DC code, because the property manager is not a board member. And I understand that it can sometimes feel like it is, because the property manager is really doing a lot of the work and is really making a lot of the decisions for the co-op, because you've got a volunteer board. And so a lot of the work is done by the paid property management company, but technically that's not a conflicted transaction under the law.
Remember, you can always affirmatively do the recusal and go through the whole process, even if it's not explicitly required.
Mm-hmm.
Kara, we would love to have you on all night answering all of our questions. I will be very honest, I have not had a webinar with this many detailed questions. So
There's a lot of
thank
good
you so much.
questions. Yeah, no, I appreciate everyone coming. I appreciate the questions. My email address is kara.spencer@dc.gov. I'm not necessarily able, like outside of a webinar context, to like answer people's questions, but and that just is because we can't give legal advice. But what I can do is again, if you are aware that there's there's something someone's doing and you think it's violating the law, it's a problem, you can contact us, and then we can sort of hear what you're saying and then decide what we're going to do about it. And I'll say that sometimes there are conflicts between board members or between members and the board, where there's not really, either we can't do anything about it because the board isn't acting illegally, or it's not the kind of conflict that it's appropriate for our office to intervene into. And so those are just decisions that we make in the office. Really, they're not my decisions, but they're just decisions made in the office.
So we will definitely circulate that, and
Okay.
any additional information you want circulated, we will circulate to all the registrants and attendees, along with the PowerPoint in English and Spanish, and we'll be posting a recording of this just as soon as we can edit it. Kara, you are always welcome. We will schedule as many of these as you like.
All right, great. I'm glad everyone came. Thanks to Laura and Ryan for translating for this long time. And yeah, I appreciate everyone's questions. Thanks again, Adam, Kiva, for setting this up. I could never do this technologically. So this is great, and we really appreciate it.
Glad to have you. And with that, I will add something that always comes to mind when we talk about this is a wise woman once said, the law does not protect you against someone being a jerk. So unfortunately, there's a lot that we have to deal with ourselves. And for other items, we go to the experts. And I will hand it off to Kiva to close us out.
Thanks, Adam. Thanks, Kara. Thanks to our community partners. Thanks to the interpreters. Thanks, everyone, for being here this evening. It was very, very informative. I hope you took a lot of notes. I do want to let you know before you go that you're invited to our next training session, which will be on September 28th. This one is called The Use and Importance of Insurance, and it will be facilitated by attorneys at Covington and Burling LLP. So you see the information there on the screen. And Adam, could you put the registration information in the chat, please? And I would be remiss if I did not invite you to join our movement to become a member of the Douglas Community Land Trust. So Adam, you can also, if you could also put the link in the chat to our website. We're a membership organization with a democratically elected board. And you can just go to the website and learn more about the Douglas Community Land Trust, what we stand for, and the lofty goals that we have, and we'll welcome you to help us in achieving those goals. We do have a new member or prospective member orientation on the first Wednesday of each month. So you can learn more about the Land Trust on the first Wednesday of each month. And you can register for these trainings, these orientations on our website as well. So with that, have a wonderful night, everyone. I know you'll be thinking about all of these
statutes and stuff tonight. So thanks for coming and take care until next time or next training. Have a good night. Bye.
Thank you, everybody. And thank you for the questions. If you had questions that you are very interested in and weren't addressed, you can email me and I will try and send places where you can go for more information and more topics. Help me and my colleagues at Douglas CLT plan out more effective training. So thanks again.
Bye.